Good afternoon. Welcome to the second seminar of our series on emerging trends in criminal justice here at Osgoode Hall Law School. Today we're very pleased to have with us a longtime friend, Professor Vincent Chiao, who is Associate Professor at the Faculty of Law of the University of Toronto. Vincent Chiao has been involved with many projects that we've had at Osgoode and also at the Nathanson Center, which is hosting the series. And so we're delighted to have him with us. Vincent holds a PhD in philosophy from Northwestern University as well as a JD from Harvard Law School. He's published numerous papers in basically the who's who of legal theory, newspapers, academic papers, should I say, including legal theory, criminal law and philosophy, the No Criminal Law Review, and Law and Philosophy. Most notably, perhaps, is the recent publication of his book, entitled Criminal Law in the Age of the Administrative State, which was published by Oxford University Press in 2018, and will be the subject, I take it, of a forthcoming symposium in the Jerusalem Review of Legal Studies. So Vincent had offered to present part of his book, but because it's been published already and he has an exciting newspaper that he's working on, we asked him to move on and to present that new paper to us. So we're delighted to have Vincent with us today to present a paper entitled Predicting Proportionality. So as usual, in terms of our format, Vincent is going to present this paper, 30, 40 minutes?
Yeah, something like that.
Something like this, and then we'll open to the floor for questions. The floor is yours, Vincent.
Okay, thanks, Francois. Thank you for inviting me. So I'll just walk through the gist of this paper. It's meant to be kind of a little bit of a departure in that it's a proposal. It's a proposal for developing a machine learning algorithm to assist in the sentencing of criminal offenders. And the main gist of the paper is to think through some of the normative case in favor of such an algorithm. I'm obviously not proposing any particular algorithm here. That's not the gist of it. But so the sort of two problems that I think of this proposal as addressing are arbitrariness in sentencing and bias in sentencing. So arbitrariness I think of as if you have identically situated offenders who receive substantially different outcomes. So these would be outcomes that vary for reasons that are unrelated to the crime, whether it's difference in judicial philosophy would be one, but also different cultures and different courts. Some courts are considered stricter than others. Other things that are maybe less appealing would be things like the judge's mood or the time of day or things of that nature. And bias in sentencing is differences in outcomes that reflect judgments about the worth of the individuals, of the accused or the victim. So if minority victims or minority accused receive different types of punishments, men versus women, wealthy versus poor, things of that nature. And so these types of concerns about sentencing are very familiar. There's nothing new about these problems. They've been around for a long time. And they provide, I think, the backdrop for debates that many of us will be familiar with about discretionary sentencing versus more structured sentencing, whether in the form of loose guidelines or really strict grids. Sentencing in Canada and in much of the United States is a largely discretionary affair, so there are statutory caps on some offenses. Some offenses have mandatory minimums, but for most offenses there's a pretty wide range within which a judge can sentence a person. And I guess I should also say I'm primarily concerned with custodial sentences. Those are not most cases. Custodial sentences are not the default outcome, but that's primarily what I'm interested in this case. So the idea of developing an algorithm to help with sentencing is, in some ways, should be familiar because we've started to see algorithms, for instance, in bail is where they're most commonly used. So risk assessment algorithms in bail to help determine whether someone's a good release candidate, whether that person's going to commit further offenses or fail to show up for their trial. There are some in the sentencing context as well, but those are also risk assessments with respect to the accused. They're sentencing algorithms that try to predict, is this accused person going to recidivate within some period of time, 3 years or 5 years or whatever it might be. What I have in mind is a little bit different in that it's an algorithm that's trying to predict not what the accused is going to do, but predict what the judge is going to do. And to say, what would the modal judge in this jurisdiction regard as a proportionate sentence for a case like this one, in a case with these facts. So, if you were to assume that this, this is a non-trivial assumption, but if you were to assume that we had a rich enough data set, that is, cases that had the factors relevant to sentencing were apparent on the record, and a judgment from the judge as to what that judge regarded as a proportionate sentence, and if you had enough of those cases, you could train an algorithm on that data to predict, given certain inputs, what would you predict the outputs to be. And one of the nice things about this kind of algorithm is that you can imagine having it be a learning algorithm so that decided cases, right? So it makes a prediction, the judge either accepts it or departs from one way or the other, sentence is handed down, and that gets fed back in as part of the data, so, as further data to improve the learning of the algorithm. So the algorithm over time should get more and more accurate. So I think of this as kind of like algorithms that you might see on, say, Netflix, right? To predict what, given that you've liked these 10 movies, what are the other kinds of movies or TV shows that you might like? And the more you use it, the better it gets. The proposal is meant to be a prediction that the sentencing judge should take into consideration, but not meant to be binding on the judge. So it's not a mandatory requirement. It's in a sense that you can think of it as the algorithm is saying, look, based on what we know about all the other cases decided in this jurisdiction, this is what your peers think of as a proportionate sentence for a case like this one, right? Maybe you can depart if you think this is particularly unusual in one way or the other, but just so you know, this is what the typical sentence would be. And there's another reason for making it discretionary or maybe presumptive rather than mandatory, which is that if you look at Section 718 of the Criminal Code, this is the main sort of sentencing provision. 718 is essentially saying, well, why are we sentencing people in Canada? And it says, well, it's denunciation, it's deterrence, it's rehabilitation, it's a reparation to the victim. It's just a laundry list of stuff, right? And the thing about that is that what 718 tells us is that we don't actually know why we're sentencing people in Canada, because many of these things point in opposite directions, right? If you want to make reparations to the victim, putting someone in jail is probably not going to help you do that. If you want to, there might be some crimes that you just can't deter, and so there'd be no point in sentencing, but yet you might still want to denounce them. And so it's a laundry list of purposes that just are at odds with each other very commonly. And given that at sentencing, the judge basically needs to say, well, I've considered them all, and this is the factor I take to be the most important in this case. 718 says, look, we disagree as to what the purpose is, and so it's very hard to make a very tailored specification of the punishment. Unlike, say, bail, where you sort of have an idea, like, this is what the point of bail is. This is to make sure you show up and don't commit other crimes in the interim. With that said, I do think if you look then at 718.1, that provision says, well, look, whatever sentence you hand down, it has to at least be proportionate to the gravity of the offense and the responsibility of the accused. So I think if you taken together what 718 and 718.1 tell us is, well, we don't really know why we're doing this, but we know whatever reason we have to do it in a way that's proportionate. So proportionality matters to us, even if we disagree as to the other purposes. So that suggests to me that there is some value in sort of getting some reasonably accurate prediction of proportionality, even if it's not going to be ultimately dispositive of the precise, all things considered sentence. So that's sort of the gist of the proposal. In terms of what I view as sort of what's to be gained from doing this, one is you get improved consistency across cases, because if you imagine your distribution of, so imagine that you took a set of facts, a particular case, and you gave it to 100 different judges, and you asked them, what would be the proportionate sentence? And you plotted those on a curve. Imagine they're normally distributed, and there's going to be some variation that's going to describe how narrow that distribution is or how wide it is, right? And so you can imagine that an algorithm of this kind would have the effect of pulling in the tails of that distribution and making the distribution a little bit steeper, a little bit more centered around the mean. There's still going to be a distribution because judges will still vary a little bit in terms of whether they're going to depart upwards or downwards, but it should pull in the tails in terms of people who are maybe outliers in terms of having really different opinions from their peers as to what is a proportionate sentence. It can also, I think, improve bias by controlling implicit or unconscious bias towards people of particular race or sex or whatever it might be. Now, it's true that an algorithm like this one would be trained on previous judgments in that jurisdiction. So insofar as those decisions themselves are biased, the algorithm will also reflect that bias. But the algorithm, I think, is more easily controllable than the judicial sentencing philosophies of hundreds of different judges. You can tweak the algorithm. One way is, a very common way is just by removing, not allowing it to consider demographic factors or factors that are strongly correlated with demographic factors. Another way is you could just build in a requirement, an output requirement, that yield equivalent predictions for people in equivalent demographic categories. Right? You could build in some sort of equality constraint a little bit more easily with an algorithm. So there's a really interesting study in the bail context on this I'm happy to talk about, but the gist of it is it found that a bail algorithm compared to human judges in bail courts the algorithm was able to both increase the number of people released pending trial and decrease the number of offenses committed during that period, and improve racial fairness of the composition of detainees. All of those criteria were satisfiable. So it's an open question whether that would be generalizable to other contexts, but that's sort of the point here, is it is a possibility. The other thing I guess I would say about this is what I would have in mind here is that unlike, say, other attempts to use sentencing, to use complicated sentencing metrics, I view this as the sort of thing that you could encode into a website or even an app on your phone. Right? And my assumption here is that most of the factors that are going to be most predictive of your sentence are not going to be particularly legalistic. They're going to be relatively intuitive factors, so that accused persons would be able to figure out for themselves pretty quickly what the likely outcome would be. For instance, if they're contemplating a plea deal. And so I think of this as it would improving access to justice by making it easier for accused people themselves to get this kind of information, which otherwise you'd have to get through defense counsel, which assumes that you have defense counsel and assumes that you have experienced defense counsel who understand what the going rate is for a certain type of offense in this particular court. It also thinks, on the side of defense counsel, it would also be a benefit in that you could sort of see what it might make most sense to focus your energy on. So imagine you're going into a sentencing hearing. a defense counsel's time is limited and the judge's attention is limited, and if you could see, oh, well, if you could play around in the app and you could see, oh, it looks like, well, if I argue about what this guy's motive was, it doesn't look like that's going to move the needle very much, but if I argue instead about how much harm was inflicted, maybe that's going to be more consequential or something like that. You could imagine sort of having a little bit more control over the outcome in that respect. So that's a general kind of a thought. Now, there's lots of different challenges that you might think of in this regard. I think the main sort of philosophical challenge is one from this view in meta-ethics called moral particularism. And the main claim here is pretty intuitive, and it's just the idea that what is an aggravating factor in one case may be a mitigating factor in another. That is to say that moral judgment isn't comprised of simply adding up features of a situation that have an invarying valence and weight, but rather each moral situation calls for a judgment taken on its own. Right? So the good example of this is the Latimer case, where you might say, normally speaking, in many cases, if I assault or harm a family member, the fact that that person is a family member is aggravating, right? Because that's a violation of a relationship of trust. But in a case like Latimer, where the father ends his daughter's life out of a concern for the suffering, you might say, oh, actually the fact that that was his daughter in this case makes it mitigating because it reflects that he was actually acting out of concern or something like that. Right? So that's a case in which I think the particularists type argument is strongest. And those are, the reason I think of those as that kind of concern as an objection here is because it's often raised in these debates about whether you should have guidelines or grids or any kind of more structured sentencing, on the view that no, we have to have completely discretionary sentencing because each case is unique and no kind of rule-like system could ever adequately reflect the moral particularity of each person's case. I think that seems like a compelling argument. The response is that the thing about a machine learning algorithm, particularly as compared to, say, a more traditional regression-based model, the machine learning algorithm is just trying to find correlations between inputs and outputs. So it's not encoding a theory of anything. So it's not trying to mimic, it's not trying to apply a theory of proportionality, like what is proportionality, and then you sort of say, oh, well, status of the victim counts for X%, harm Y%, and criminal record Z%, and you add. No, it's not doing any of that. It's just saying we got a bunch of cases with hundreds of different dimensions, and you just predict an outcome based on that. Just in the way that your Netflix algorithm is trying to predict your taste. And what's important is that if it's accurate, it's not, the algorithm itself doesn't have to model the way you form your taste and the judgments you make in determining, oh, I like this movie or not that movie. The algorithm doesn't do any of that kind of thing. It just makes a prediction. Do you have a?
I just don't understand. I don't know how algorithms work, really. I would just, does anyone else know? I don't know. It would be like so helpful to me if you could give us like super helpful, because I feel like I don't even have this like some base of knowledge to figure out kind of like what the basic just mechanics of it.
Yeah, I mean at its most simple, an algorithm is just a structured set of steps. Right? So a recipe for making cooking a dinner is an algorithm at its most simple form. Another sort of very simple form is
cooking is an art form.
Cooking, right? You can do it sort of without a recipe, or you can do it with a recipe, sort of set of steps. So you can, there was a popular Atul Gawande.
We always end up missing the worst stuff.
Nathan Myhrvold, the Microsoft guy, is also a big famous chef who publishes books of 1,000 pages about how you should cook something for exactly 27 seconds and then move it for 13 seconds if you want the perfect burger or something like that. So So you would say it's not an art, it's a science. It's just for many years you thought mistakenly it's an art.
Well, but there's also, so Atul Gawande wrote a famous little essay in the New Yorker some years ago about why doctors should have checklists in their hospitals that just make sure they go through the steps when they're doing routine surgeries or whatever. And he argued that that's improved outcome. And that's just an algorithm. The checklist is just an algorithm. But in this context, there are more and less sophisticated versions of it. Some of them operate by essentially trying to do a multiple regression where you have you guess weights for various factors, and then you compare outcomes, and then you adjust the weight for those factors. So if you imagine you're trying to predict the slope of a curve, and you just guess, and then you see, depending on where you are, you just change your guess until you minimize your error rate. There are other more complicated ones called neural networks, which are meant to mimic, in a very abstract way, the way that the human brain works. And there you have multiple layers of decision nodes. The interesting thing about neural networks, which I think is probably very for many people very confounding aspect of them, is the neural network, as it trains itself on the data and updates its parameters, it starts responding to features in the input data that humans don't really pick up on, that don't make sense to humans. Right? So if you have one that is trying to do facial recognition, and you just have a grid of 100 by 100 pixels, right? The neural network could start seeing patterns in the pixels that don't make any sense to a human, but they might ultimately help the network be very reliable in picking out faces. And so that something like that could be going on in many of these kinds of contexts. That's what makes people worry about these types of algorithms, and that we couldn't really say what is it about the algorithm that it's making it come up with these predictions. So those are sort of I think the more complex forms. There's a sort of a very common kind of normative challenge to the use of big data, predictive analytics type stuff in criminal justice. And this is that sort of feeding forward prior discriminatory patterns. So one of the things that you find is that, I mean, crime is just this kind of thing that if you look for it, you will find it. And so it's really quite sensitive to enforcement efforts, as much as, if not more than, sort of its actual incidence in a population. And so the concern here is, like, you know, if you say, well, black kids have more police contact than white kids, and that translates into a longer criminal record, even for equivalent conduct, then surely if you're saying criminal record is relevant to proportionality, this is just going to replicate that. And it's true. It will, to a certain extent. But the question, I think, is always compared to what? And compared to the status quo is one where we're already replicating that bias. So the most obvious fact that we're all familiar with is that our jails and prisons across North America are marked by huge racial disparities. So it's not like we've got a racially fair system to begin with. And that system that we do have that is racially biased is built up by judges and prosecutors and police exercising their discretion in an intuitive case-by-case method, considering things like criminal record. And so, you know, we already have a pretty biased system, and it's one that's biased by feeding forward prior discrimination at prior stages. And so the question really, I think, is just, could an algorithm do better than that? Could it be better than the status quo? And there, I think, there's evidence, you know, again from that Bale study, that suggests that it could be. There's a bunch of implementational challenges. I'm happy to talk about them. I think the main thing I would just say about that is, it turns out this is not like some crazy thing that's never been thought of. Here in Canada, Tony Dube tried something like this in the 1980s in Manitoba, and I believe Alberta, and there was something similar in BC as well by a guy named Hogarth. So a generation ago, efforts were made to do a kind of computerized sentencing project in Canada, and they failed. And the reason they failed was largely because judges didn't buy into them. Judges resisted using them because judges trusted their own discretionary judgment more than these more actuarial sentencing tools. So I think in terms of implementational challenges, that is actually, I think that kind of social challenge is probably bigger than any of the technical challenges that there might be. Getting judges to buy in, because if they don't buy in, you know, you're just not going to be able to change sentencing practice, I don't think. So that's the gist of it.
So we have time for plenty of questions. So Professor Priel, we just have to make sure to pass the microphone around for recording purposes. Thank you.
Great, thank you. I'm a big fan of use of tech. I don't believe that sentencing is an art. That's sort of a bit of bullshit the judges tell themselves because they want to feel special. But so in principle, I'm friendly to very friendly to the idea. And so a few kind of thoughts. So one. So I mean, you addressed the concern over the fact that judging is sorry, let's start again. So when you're saying that you want still to maintain the idea of proportionality, you're still saying that the basis for incarceration is some sort of intuitive sense of what a particular wrongdoing is worth. But when you try to probe deeper into this, there's really, it's very hard to find anything there, right? And that's where retributivists get challenged on all the time, right? So they say, oh, the sentencing is or punishment should fit what the offender deserves. So what does that even mean, right? It's almost, and then when you come to this and you try to understand where what it means, it really is based on nothing but a feeling. So the question is, whether do you want to maintain this as the basis for sentencing instead of, so the alternative, which is also sort of another model of using science, is to kind of say these notions are yeah, we have this sense of proportionality that which manifests itself in all sorts of other ways in real life, karma, right? But when you kind of look more deeply into this, it's not based on anything that you can that's sort of morally or scientifically respectable. So why do that? A second question is or suggestion actually, which, so I have very, very little practical experience, but I clerked in a court, and so not in this country, but I don't know if it's any different, but at least where I worked, so sometimes the question would come about, would be raised about what's the appropriate sentence for a particular crime, and the lawyers would just start giving, oh, here's an earlier case, and here's what the offender got there. So in a way you're saying, I propose basically what's been going on, except that instead of the kind of haphazard way in which it's currently done, I just want to give you judges a much more refined or much better information based on a much bigger data set. Instead of here are 5 past cases in which on which you judge are going to say, okay, that's a little bit harsher than this one, but a little bit lighter than, so I kind of going to go in the middle between these two cases that counsel gave to me. I'm basically offering you something that's essentially what we've been doing all along, just much better. And finally, on particularism. So I haven't had the chance to see the paper, but I know that within the domain of just moral philosophy, particularism has been challenged, and I think quite persuasively. So I think there are good answers to the claims. So even to give the example that you gave, so if you read Dancy, who's sort of the big particularism guy, he would say that it's sort of like almost, it's completely unpatternable, right? The way that factors figure in sort of making something worse or better. But in fact, it doesn't look this way. So even in the example that you gave, there was a pattern, right? So you said in those cases, it reflected badly on the fact that the crime was committed against a family member reflected something that made it worse. But in those circumstances, it reflected differently. And you could give a reason for this. So the problem may not be that there's, or the response is that it's not that there are no patterns at all. It's just that they're more fine-grained than the type that when we talk about, when moral philosophers talk about, when they kind of talk about moral principles, they would, so the moral principle is not, if you do something to a family member, it's always worse kind of thing. That's just not the right moral principle. So these are 3 thoughts.
Yeah, great. Thanks, Danny. Maybe I should just go in reverse order then. I mean, on the particularism point, I mean, I raised particularism as sort of a challenge to the kind of proposal I'm defending. So if you're not a particularist, then I think you have even more reason to sort of, or let me put it this way. I think the best defense of discretionary sentencing is one that rests on some version of moral particularism. If you're not a particularist, then I think the moral case for discretionary sentencing becomes much harder to make. So I'm basically agreeing with you, and so on the particularism issue, I mean, there are different varieties of particularism, and the kind of moral judgment is completely unpatternable is a very strong version of particularism, and I do think we really do need to reject that kind of particularism. And I don't find that in the least bit compelling, I have to say. In part because if you sort of think about the complaints that have been raised about sentencing, about arbitrariness and disparity, those complaints don't even make sense if you have the view that moral judgment is completely unpatternable. Because the idea that moral judgment is completely unpatternable means that you can't compare 2 cases to each other. And so if a white individual who commits crime A and a black individual who commits crime A under exactly the same circumstances, one gets a higher sentence, you can't call that discriminatory because they're just completely different cases, and you can't, and that seems much too strong. So I agree with you about, I don't find that version of particularism particularly compelling. And so the way I kind of express this in the paper is there's a form of particularism, a weaker form of particularism, that has to be consistent with the supervenience claim, which is that proportional sentence for 2 cases that are identical, the sentence has to be identical, and what's proportional for one case is different for what's proportional in another case, there must be a difference in the underlying facts of the case. That, I think, that supervenience claim, I think, is fairly hard to resist. It's a fairly compelling version of fairness in sentencing, I think. So yeah, I take your point that one way of understanding Latimer is not that, there are no general rules in moral judgment, but rather that the rules that we have are just more complex, right? So you can say that You could imagine the rules being conditional, like super long rules. You could also imagine, sort of if you're more inclined towards a weaker form of particularism, you could imagine the rule being that cases in which you have harm to a family member with no malicious intent are just different type of input than cases in which you have harm to a family member with the malicious intent. Right? That could just, that could be the thing that you think. On systematizing existing practice, yeah, that's exactly what this is meant to do, and I think the sort of advantages are meant to be, A, it's supposed to be more accessible, it's going to be cheaper and easier and faster because you don't have to go through the expertise of a lawyer to sort of figure that out, and B, it should actually enhance the quality of judgments, because, you know, I have been to sentencing hearings where if you go to sentencing, if you're the judge, you are dependent on the quality of the counsel to bring forward the cases that are relevant. You're depending on the quality of their research, the fairness of their research. And you're also depending there on a relatively small number of cases. So imagine you've got someone who commits, who's been convicted of an aggravated assault. It's sort of middle of the range. This person has a record, but it's maybe a little bit dated. And there's some mitigating things in the pre-sentence report or something like that. And then you get 10 cases. Some might be simple assault, some might be much more egregious. Some people are going to have much longer priors, some are going to be first-time offenders, maybe just lots of different things, and it's just going to be hard on the basis of those 10 cases to figure out a comparison. And often what you'll see judges do is just, as you say, just tack down the middle, which is understandable, but perhaps not entirely principled. If you have an algorithm that has an inferential basis of hundreds, thousands of cases, all the cases there are, the thought might be its prediction would just be a little bit more informed. But that gets you to your first question, which is this, if I can put it this way, isn't proportionality just baloney? Like, why deal? And, you know, maybe. I don't want to really want to. I mean, I'm trying. What I'm suggesting in this paper is that proportionality, whether it's baloney or not, is a pretty stable part of our legal systems and something that, like, if you look at 718, and this is not just a weird thing about Canadian sentencing, you see this in almost all jurisdictions. People cannot agree on what it is we're supposed to be doing when we're punishing on the purposes. But there's a lot more consensus that whatever it is, it really needs to be proportionate. So actually the Israeli sentencing is like this, the first thing that the judge is required to do is say, what do I regard as a proportional range for this? And then you can sort of.
Can I just give you one helpful point on this, which you kind of said. So there's two senses of proportionality. Proportionality is fit between the crime and the punishment, that's the part that's really baloney kind of thing. But there's the internal one. So whatever it is that you think is appropriate for whatever reasons for simple assault, you want to make sure that, so it could be, I can't tell you that 6 years is proportionate for simple assault or 20 years is simple. That's just
the
magical stuff.
proportionality.
But internal one, if you think that it's 6, it should be 6 for everyone. If you think it's right, and that's
it's a consistency.
Exactly.
Kind of,
So, and that's.
Yeah.
I also have a number of questions that are more disjuncted than Danny's. So we now know that some police forces, at least across the United States, I'm not too aware of practice in Canada, use predictive tools to figure out where to police and where crimes are likely to happen and by whom. Right? And one of the criticisms of these tools is exactly what you said in your presentation, that sometimes you will find crime if you look for it, and therefore you're just replicating certain patterns of criminality. And so with respect to the sentencing algorithm you propose, you said at some point, well, it'd be useful for judges to use presumptively at the time rendering the decision, but it might also be useful for an individual who's considering whether to enter a plea or not. right? So the forward-looking aspect of the algorithm is something you deem useful, as well as the backward-looking. Do you see a distinction there? Because the same problem might happen with respect to the person who, at the level of making a plea deal, looks at what the algorithm is saying and saying, okay, based on this, I am going to therefore take the plea. Because that's, in a way, it's going to compound the model. It's going to feed where crime or where which sentences are found. So do you think the site or the moment where the algorithm is used matters and should be something of import? So that's the first question. The second question ties a bit to it, that last bit about cardinal proportionality. So how do you decide which jurisdiction to look at? So in Canada, you could look at what sentences are rendered in Toronto. It would be very different, presumably, than what's rendered in Thunder Bay. Right? You could look at Ontario. You could look across provinces, right? You'd compare Ontario and Alberta. We all have one criminal code, so one reason to do this might be, well, okay, we should do it to have a pan-jurisdiction model. But then there might be also arguments for saying, well, actually, we should explode this and look at all Anglo-American jurisdictions which have similar systems, because that might allow us to control much better for things like racial biases, et cetera. So the US would gain to look at what's happening, say, in Canada, Australia, or other jurisdictions. So how do we then pin down where to draw the jurisdictional boundaries? And finally, it's a bit tied to this, what data do you then feed into the model, right? So there are different models. I'm not an expert in algorithms, but I know something or two about regressions. And there are different schools of thoughts about regressions, which was one model is basically you just send the computer to look at what's happening, neural networks, find patterns, and then just replicate this. Another model is, well, we're going to decide what variables matter and, at least have a sense of how they should play a role and feed that into the model. What are you suggesting we do?
Okay. Great. So again, sort of in reverse order, I guess my thought would be more of the neural network kind of approach, precisely because of some of these particularist type concerns, where if you are inventing a model and then sort of deploying the model, you are creating a theory of proportionality, and then that's what the particularists are going to object to and say you can't have a general theory of proportionality. Whereas a neural network, you say, like, I have no theory. I'm just finding correlations between really dense data and
because one
outputs.
of the plus of, or argument in favor of your model was it's going to be easier to control for specific variables, like try to exclude unconscious bias, etc. It seems to me that the neural network kind of approach makes it harder, because then it becomes, as you said, impenetrable. So it might be that in certain, let's say, majority black community, the sky is grayer, and that this has an effect on sentencing on the data, right? So then how do you control for this? Like, how do you build that into your argument?
Yeah, so when you train the algorithm on correct, you train it by saying, okay, create your predictions and then we compare them to the correct outcomes, right? And it could be just the correct outcomes on which the algorithm is trained, or just the sentences that were in fact imposed in that jurisdiction over the last 10 years or whatever it might be. But you could also gerrymander the training data, right, and say, no, we're going to impose some order on that training data such that you get the same proportion of indigenous as are represented in the general population, or whatever it might be, whatever your target outcomes might be. And that could be used to train the algorithm. So the algorithm is being trained not on the actual observed outcomes, but a laundered version of the outcomes. Aziz Hook has a new paper in the Duke Law Journal which sort of discusses some of these issues. So that's kind of what I have in mind there. The size of the jurisdiction question is really interesting to me, and I find this a really fascinating question. I don't really have any great answers to it. So when I teach first-year criminal law, I always start by talking about federalism, because in the states it seems very natural. Historically, it's not just the states. I mean, Australia does it this way, and this is how criminal law developed in England. Criminal law was local law. Of course it was local to the jurisdiction. That's just how it always was. And so it seems very natural to say, well, each state, we sort of have a stronger sense of states as being separate, distinct political communities, has a stake in defining its criminal law for itself. Whereas, my students here seem to think, no, criminal law has to be national. But then you ask them, well, what about the administration of criminal justice, which is a provincial matter? And they say, oh, no, well, that has to be well, why does that have to be well, because, it's just local and each community is different. So it's hard to, I think, sort of get a real, I think there's sort of just deep political questions about this, or what sort of the unit of political analysis is here. But certainly it could be useful in, say, quantifying, making public the sort of sense that many practicing lawyers have that different courthouses have very different rates for different types of offenses. If you, as you say, if you're in a rural community versus downtown Toronto, what you're likely to get. And sort of knowing that would be, I think, useful, right? We could have a conversation like, should there be this kind of variation, or maybe should we clamp down on it? I think that's a hard question, but me personally, I tend to sort of think, there's maybe better reason for uniformity across some of these cases. But
because for me, so your take on criminal law is a political one, right? So it's more tied to jurisdiction. Somebody who's more of a legal moralist will say, well, actually, just blow up those boundaries. If gravity is a factor, well, gravity should be a factor across the board in all jurisdiction. And these algorithms might actually allow us to compare this in a way that's useful from a moral standpoint.
Yeah, potentially. So I do mean this to be sort of ecumenical across. I mean, you could be a Duffian and sort of think, no, it is a moralist, but it's a moralist that's tied to a local community. I mean, you could have different views about this. The plea versus sentencing thing, that's a great point. My sense about that is that the input data for the algorithm should be sentences imposed by a judge rather than after some discussion on the merits, rather than say an agreed to plea by the parties, where the judge is essentially just validating the agreement. And that's because when the judge is essentially just validating a plea agreement, it's really hard to know what it is that led to that, and that judgment is plainly not one that reflects proportionality. It reflects lots of other things, like I want to get out of jail right now, or something like that.
But the point was broader than this, right? So if I know that going for this charge as opposed to this charge is going to probably result in this much higher sentence, I might just go for the lower charge.
Yep.
The sentence might still be decided by a judge, but the way the facts of the case feed into the charge and then our sentence will be modified by the application of the algorithm at this interstitial point, right?
Yeah. No, that's a really, it's a complicated question, because it was essentially some version of that kind of problem that caused the failure of the federal sentencing guidelines. And what you ideally would want is you'd want the algorithm to be trainable on a rich description of every case, of the true facts of every case, regardless of how they were formally charged and pled, and that gets very, very hard to do.
Isn't one way to do this to just say restrict the application of the knowledge of what comes out of the algorithms to judges? There might be a transparency concern there, but
yeah, I get you could. But even if it's only accessible to judges, I mean, still what the judges themselves see is going to be limited. And I do think one of the main appeals, for me anyway, of an argument, of a proposal like this, is sort of democratizing knowledge that's otherwise held in expert hands, and sort of making it accessible to the people who are most directly affected by it.
Professor Pacheco.
Thank you. I love this. It's so interesting. And I have a number of thoughts, none of which has sort of crystallized into a penetrating question yet, but I'll just kind of spray them around the room and see what happens. The first couple of thoughts are actually just on this point about plea bargaining. So they're sort of just observations about plea bargaining. One is that I wonder, with this democratization point about imagining a world in which somebody could go on a website and get a pretty clear sense of what sentence they would be facing, I wonder if that would potentially have the effect of discouraging people from seeking legal advice on the theory that they ought to just plead guilty as sort of self-reps because they're now more empowered to, to have a reasonable conversation with the Crown Attorney, which prima facie to me looks like a good outcome in that it levels the playing field a little bit more because you don't just have the Crown as a repeat player who understands the going rate. You've got the defendant that's sort of a little bit more empowered, and also in many cases people obviously can't or can barely afford counsel. But what I worry about with that is that there's actually sort of two factors, right? There's the question of what sentence should follow from this set of facts. And also there's a question of which facts can be proved in law, right? And people might know that they did X, Y, Z, that they had this motivation, that, there were these circumstances, but they won't necessarily know which of those facts would be found beyond a reasonable doubt if they went to trial, what defenses are available and whatnot. So I just wonder if it might be the case that you would have people with a viable defense pleading guilty, or people accepting a plea deal premised on facts that couldn't actually be proven under just sort of basic procedural evidentiary rules, and to what extent that would be a problem. Maybe the answer is just, even if that happens, it's probably not going to be the overwhelming majority of cases, and the countervailing considerations in favor of democratization outweigh it. But I just put that out there in case it's of any interest or sparks anything. And then I was also, I think I had a second point about plea bargaining that's escaped my mind, so maybe I'll return to that later if I can. But I'm curious about the fact that on this model, judges would have the discretion to depart, and presumably they would have to give some sort of reason for so doing. So it strikes me that if you had judges who were more or less likely to depart by virtue of sort of constellations of political commitments, you could end up in a situation where the departure rate tends to more frequently result in sentences that are higher or lower than those suggested by the predictive algorithm, which then get fed into the algorithm, and thus sort of over time gradually shifts it one way or another. Obviously, there's a big empirical assumption here about whether there are particular political leanings or commitments or views about the law that are going to lead people to trust their discretion more, trust the algorithm more. But I just put that out there in case it's of interest. I don't know, again, this is a pretty nugatory point, but it struck me during the presentation, so I thought I'd offer it. Right, and I think I've now recalled the last point I wanted to make, which was also regarding plea bargaining, so I'll circle back to that. I understood you to say in response to Francois's question that you would think that the algorithm ought to be initially populated by cases that were decided following a trial and not by pleas. Am I correct?
Yeah.
So I'm just wondering, right, on the one hand, that gives sort of richer content and context and allows us to look at more fine-grained distinctions than are available in a plea agreement. But on the other hand, are those really representative cases given the fact that the overwhelming majority of cases are pled out, and that often if people go to trial, it's because there's something either unusual about the case that gives them a sort of a greater hope, or perhaps it's just a difference in terms of the level of privilege of the defendant and their ability to afford counsel. But it strikes me that Crown attorneys, for example, are more likely to insist on trial and make plea bargaining difficult if they want to set a precedent, make an example, if they've got particularly strong concerns about the community reception of a case, if they're gunning for a higher sentence for reasons of, public interest and so forth. So I just wonder if you've thought about whether that would achieve the goal of doing something like current common law practices, but better, or would it actually be different than current common law practices to the extent that the latter are sort of informed explicitly or implicitly by this sense of the going rate that includes cases driven by plea? Maybe that's not correct, because obviously guilty plea cases are not all reported in the same way. So I'm not sure about that. It might be that the common law practice of looking at, a sampler of a dozen cases is itself skewed by the fact that guilty pleas are not reported. But it just strikes me there's something going on there that might be worth probing.
Yeah.
I'm not sure that it is, but in case I leave it to you.
Great, thanks, Palma. Those are really perceptive and probing questions. I guess I don't know if this would discourage people necessarily from seeking counsel. Certainly if they, in terms of people who have access to duty counsel for free for sort of low-level stuff, would presumably not disincentivize that, since there aren't any costs necessarily from doing that anyway. And if it's a serious enough case and you can afford legal aid or private counsel, I don't necessarily know that this, it could, I don't know. What I'm more focused on is, are there people who can't afford counsel or who can't get good, competent counsel who know what the going rate is, and then they can find out what the going rate is. In terms of the question there about, well, are people going to plea when they shouldn't, essentially, when they're going to waive either factual issues about what the Crown can actually prove, or legal issues about defenses that they might have available to them. And I share those concerns. I guess I don't know offhand whether this would exacerbate those concerns beyond what's already kind of present in the plea bargaining context, when you can have, if you have a big enough discrepancy between the trial rate and the plea rate, people will regularly plead to things where, who knows if the complainant will show up and the Crown can prove their case. Who knows? So I guess what I'm saying is I'm sensitive to that issue. I'm just not, I don't know if this would exacerbate it or not. If it did, that would certainly be cause for concern. In terms of whether trial cases are representative, they're clearly not along various dimensions. My sort of sense about that is that the received wisdom, as I understand it, and you will know this better than I do, is that the trial, the plea negotiations take place in the shadow of expectations about trial. And so it's not that the trial is representative of what most people get for assault, so much as that if you know that at trial this is what you will likely get, then that sets a baseline from which you can then bargain about what you will or won't accept by way of a plea arrangement. And so this idea here is just sort of systematizing that trial outcome, and so people can have a more clearer idea ex ante. Okay, what we're talking about is not, anywhere between 6 and 18 months. What we're talking about is likely 9 months, right? And that's what I would probably get at trial. And now we can talk about what I would get if I gave up my trial rights. You could also argue about, I guess, sort of going back to your first question about, if you could say, oh well, if the Crown can show malicious intent, I'm more likely to get 10 months. But if it looks more like, if the judge is more convinced that this was just, gross carelessness, it'd probably be more like 8 months or something like that. You could argue, you could sort of figure out which kinds of issues might be more material and worth arguing about. And that might also play out in the plea arrangement. Sort of, well, I've got some evidence that this wasn't, things like that. Is that?
Yeah, no, that's all great, and it does remind me, part of your response reminded me, another issue with premising the algorithm on trial outcomes as opposed to the aggregate of trial and plea is that currently there's an understanding that people get a discount for pleading, right? Whether or not there's a plea bargain. So you've got sort of what's referred to as the trial penalty. So predictably, trial outcomes for equivalent cases are going to result in higher sentences. So when you're predicting proportionality based on that, what you're actually doing is predicting the upper end of proportionality, which isn't necessarily problematic because that would suggest that repeat players should then assume a discount from whatever the algorithm generates for purposes of their plea, although that's something that you'd want to maybe have as part of your website banner for defendants looking at trying to predict what would happen if they went to trial versus if they pled. Because if somebody's told you are most likely to get 9 months if you go to trial and lose on this, a 9-month plea bargain's a bad deal.
Yeah,
right?
Absolutely.
But a person who's not sophisticated and sees that that's what they're looking at might say, I could hack 9 months.
Yeah.
I'm not going to bother
Yeah.
going to trial over this.
Yeah, I mean, you could imagine of a court that was, or a jurisdiction that was more interested in regulating plea bargaining than ours is. You could imagine fixed discount rates, right? Say 30% rate, and so you would know more specifically, not 30% off something between 6 and 18 months, but 30% off 9 months would be. And if the Crown is offering me only 10% or whatever, I'm going to say no. Something like that. Like you could have a clearer understanding of that. It would kind of make regulating the plea a little bit more easy, I suppose. But that just presupposes that we're interested in regulating pleas, which so far we're not. And assuming that we're not interested in regulating pleas, maybe we should be, but that's another paper, I guess.
I am, but
Yeah.
yeah, no,
Yeah.
that's great. But thank you for this, and I'll forfeit the microphone in just a moment. But yeah, I did want to say one thing that makes me think of that's really nice and really elegant about your paper is what you just described is essentially what I think was sort of attempted by the federal sentencing guidelines in the states, right? That affix a particular discount on the grid. But the difficulty with the guidelines, as we know from like Stunts and others, is that the actual practice of producing them, because of the politics involved, just predictably results in the highest possible sentencing outcomes being then embedded in the guidelines and setting a new normal, whereas the elegance of this is that it can generate a similar product in terms of the consistency that it gets, but in a way that doesn't predictably and necessarily sort of artificially inflate the sentences at the front
Yeah.
end.
I do think that, for reasons kind of related to what Danny was talking about, and that the idea of proportionality here is sort of relative to what people in the society sort of view as appropriate rather than fixed in some kind of absolute sense. This kind of potential for drift that you were talking about it's entirely possible. I mean, I think that's entirely possible now with discretionary sentencing, and this wouldn't change that. If society becomes more punitive, say with respect to domestic violence cases, then this would reflect that. And if it became more lenient, say on minor drug cases, this would reflect that too. I mean, it would just kind of, as opinion changes, which may be unprincipled. I don't know, but.
No, I think that's actually an argument. I think that's an argument for the project. The fact that there's some space for drift as social norms change. You wouldn't want to be in a situation where we'd reified that sexual violence is less significant than break and enter, and so that's what we're going to just go with till the end of time, right?
No.
So I'm just thinking of this right now. A few weeks ago, we had Gabe Mendlow, who came to present a paper, which he entitled, I was trying to pull out the title.
Tower of Babel.
Sorry, the Divine Justice in the Library of Babel, or was Al Capone really punished for tax evasion, right? And one of the main points of the paper was it's very hard to know what the target of the criminal justice system is. It constantly shifts throughout the process, right? It's very hard to say, even though the system may claim that a given wrong is being targeted at trial, that this is what is the subject of, say, the proportionality inquiry at sentencing, right? So in the case of Al Capone, tax evasion might be charged, but really sentencing might be calibrated upon the fact that he's a terrible gangster that we don't have to have around, but he just can't be charged for this, right? So it struck me that your approach might be a work around this, right? As opposed to these algorithms that take all these data into account and come up with some sort of ranking or consistency sort of outcome might just, might be an answer to this, saying, well, even though we don't know what the system is about, we can tell you at the very least a consistent ordering, right? And that might be as much as we can hope for.
Yeah, though it would be, I think it would still be manipulable by prosecutorial charging discretion in terms of which count someone's going to be indicted on. It's going to structure what the proportionality analysis operates on. But that's true today, right? If you
have large enough data, then all the cases where tax evasion being charged for other reasons would then be factored into that analysis, right? So.
Yeah, I suppose so. I guess if you had enough data where you could find enough people who are like being charged for one thing, but there are facts supporting other stuff. I guess I I still don't think that that would likely be enough to, I mean, Gabe's sort of concern was largely about charging discretion of prosecutors, and that sort of source of discretion, that's a source of arbitrariness and discretion, just in the same way that judicial discretion at sentencing is a source, and sort of, I think there is real insight in that those two things have to go in tandem. Just clamping down on one, not clamping on the other is probably not going to work very well. That said, this is probably not the best means for controlling charging discretion in terms of how prosecutors structure an indictment, just because that information is not going to be available on the record by and large. But one could imagine, and I think there are efforts underway in the States to create something like an algorithm for evaluating prosecutorial discretion in terms of which charges should be made. Right? That would have to be a much more complicated algorithm because there's a lot of other factors that sort of go into the exercise of that discretion. But there are sort of back of the envelope type things that do happen, particularly for low-level offenses. Like I've been reading this wonderful new book by Issa Kohler-Hausman called Misdemeanor Land. It's all about low-level criminal courts in New York. And she, according to Kohler-Hausman, she says for many of the DA's offices there, they just have a policy if it's like a Class D misdemeanor or violation and a first-time offender, their policy is just toss it. And if it's Class whatever C, then they offer essentially go to this, do 5 days of community service, and then we'll toss it or something. So that is basically a very simple algorithm for charging discretion. So those kinds of things do exist in a manner of speaking.
Professor Priya.
So this is a thought that came while hearing you. So it's not necessarily my thought, and I actually don't think it's the thought of the person I'm going to mention today, but Alon Harel published a paper almost 20 years ago, I think, that says it's a good thing that offenders don't know what punishment they're going to get, because this uncertainty is a good deterrent mechanism. So I just thought, and I then looked at it. It turns out this idea has been, others thought about this as well, right? So the uncertainty is valuable in this way. In a way, your proposal goes against this. So you may say, well, that's just a bad idea. Or what do you say about that?
Yeah, I mean, the classic discussion in the deterrence literature about certainty is certainty with respect to whether you will get the punishment. What Alon is talking about, and there's some empirical literature about, there's an experiment I think done in the traffic context with like traffic fines or something, is uncertainty as to the size of the penalty. And I think it depends on your kind of assumptions about attitudes towards risk among your target population, about whether that will deter or not. With respect to whether you get the punishment, in most cases it seems like for most of your target population, the certainty is more deterrent than uncertainty. That is to say, people are deterred if they know they're going to get a small punishment. With respect to this kind of question, like uncertainty as to the magnitude of the punishment, it's a little bit harder to say. But again, I mean, insofar as the legal system's committed to proportionality, we are committed to some level of certainty already, right? You know that if you commit a crime, you're going to get a punishment that people generally regard as proportionate, right? It's not like you're going to get the death penalty for, parking in the bike lane, even though sometimes I suspect that might be a good idea. But so there are kind of, there is already some level of certainty, right? So, I guess
I think the paper is called Sentencing that Leaves Something for Chance. That's the, or punishment that leaves something for chance.
that's the David Lewis paper.
Any further questions? If no further questions, then we'll bring this to a close. Please join me in thanking Professor Chiao for a very thought-provoking paper, something that you might find in a courthouse near you in the not too distant future, one may think. Thank you very much, Vincent.
Thank you.